The following is a presentation of Canyon School District's administrative training for Title IX provided by the Department of Legal Services. Title IX of the Education Amendments of 1972, or otherwise referred to as Title IX, is a federal law. The statute states, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance." Title IX is a federal civil rights law that prohibits discrimination on the basis of sex in education in federally funded programs and activities. Title IX compliance. All public and private elementary and secondary schools, school districts, colleges, and universities receiving any federal financial assistance must comply with Title IX. This presentation will overview Title IX law, guidance regarding Title IX, Canyon School District policy in Title IX, and Title IX investigations. Previously in the presentation, the statute for Title IX was provided. We will begin by looking at Supreme Court cases regarding Title IX. Then we will review text of federal regulations governing the implementation of Title IX. Then we will look at Office Civil Rights letters and guidance for Title IX, Canyon School District policy, and Title IX investigations. We will now review Supreme Court cases regarding Title IX and their significant holdings. The first case is Cannon v. University of Chicago, 1979. This case and its holding is that Title IX includes an implied right of action, meaning people can sue under the law of Title IX. The next case is Franklin v. Gwinnett County Public Schools in 1992. The holding from this case is that Title IX not only provides equitable remedies to require fair treatment for males and females, it also provides for damage awards, i.e., a district can be sued for money. Supreme Court cases continued. Davis v. Monroe County Board of Education in 1999. The significant holding from this case is that a school board may be held liable in cases of student-on-student harassment, but only where the funding recipient is deliberately indifferent to sexual harassment, of which the recipient has actual knowledge, and that harassment is so severe, pervasive, and objectively offensive that it can be said to deprive the victims of access to the educational opportunities or benefits provided by the school. The next case is Fitzgerald v. Barnstable School Committee in 1992. The significant holding from this case is that Title IX doesn't preclude a 1983 suit, meaning individuals can be sued and plaintiffs may recover attorney fees. We will now review the text of federal regulations governing Title IX. As a brief reminder, federal regulation, or administrative materials, or administrative law regulations are based on a specific statutory delegation of power from the legislature. A statute identifies in general terms conduct to be regulated, and penalties to be assessed. A statute delegates to an agency the task of filling in the specifics of the regulatory scheme. The Title IX Code of Federal Regulations are located in Title 34 CFR Chapter 106. The text of federal regulations governing Title IX in Title 34 CFR Chapter 106 is divided into subparts, as you can see in the slide below, from subpart A to subpart F. A link is provided if you would like to explore further into the Code of Federal Regulations. We will now review selected regulations from the Code of Federal Regulations. The first one we will review is the Title IX Coordinator. Each recipient shall designate at least one employee to coordinate its efforts to comply with and carry out its responsibilities, including any investigation of any complaint. Each recipient shall also notify all its students and employees of the name, office address, and telephone number of the employee or employees appointed. The next two selected regulations we will review are Complaint Procedures and Notification of Policy. Complaint Procedures. A school district shall adopt and publish grievance procedures providing for prompt and equitable resolution of student and employee complaints. Notification of Policy. A school district shall implement specific and continuing steps to notify students, parents, employees that it does not discriminate on the basis of sex in the educational program. The next selected regulation we will review refers to discrimination on the basis of sex in educational programs or activities is prohibited. Discrimination prohibited. A school district shall not, on the basis of sex, treat one person differently from another in determining whether such person satisfies any requirement or condition for the provision of such aid, benefit, or service. Provide different aid, benefits, or services, or provide aid, benefits, or services in a different manner. Deny any person any such aid, benefit, or service. Subject any person to separate or different rules of behavior, sanctions, or other treatment. Otherwise limit any person in the enjoyment of any right, privilege, advantage, or opportunity. The next two selected regulations we will review refer to showers/facilities and guidance counseling. Showers/facilities. A school district may provide separate toilet, locker room, and shower facilities on the basis of sex, but such facilities provided for students of one sex shall be comparable to such facilities provided for students of the other sex. Guidance counseling. A school district shall not discriminate against any person on the basis of sex in the counseling or guidance of students. The next selected regulation we will review is pregnant students. A school district shall not discriminate against any student on the basis of such student's pregnancy, childbirth, false pregnancy, termination of pregnancy, or recovery therefrom, unless the student requests voluntarily to participate in a separate portion of the program or activity. A school district which operates a portion of its education program or activity separately for pregnant students shall ensure that the separate portion is comparable to that offered to non-pregnant students. The next selected regulation we will review refers to equal athletic opportunity. A school district shall provide equal athletic opportunity in interests and abilities, equipment and supplies, scheduling, travel, coaching opportunities and compensation, facilities, medical services, housing and dining, publicity. We will now review Office of Civil Rights Guidance, or OCR Guidance. The following paragraphs are from a letter from the Office of Civil Rights issued to school districts. The Office for Civil Rights, OCR, issues policy guidance to provide recipients with information to assist them in meeting their obligations and to provide members of the public with information about their rights under the civil rights laws and implementing regulations that we enforce, we referring to the Office of Civil Rights. OCR's legal authority is based on those laws and regulations. The guidance does not add requirements to applicable law, but provides information and examples to inform recipients about how OCR evaluates whether covered entities are complying with their legal obligations. OCR Resources and Materials. The Office for Civil Rights, OCR, enforces Title IX of the Education Amendments of 1972, which prohibits discrimination based on sex in education programs and activities that receive federal financial assistance. Issue areas include sex-based harassment, including sexual harassment, sexual violence, and gender-based harassment, harassment and bullying, pregnant or parenting students, athletic opportunities and benefits, retaliation. Sexual harassment guidance issued from the Office of Civil Rights and the U.S. Department of Education in January 2001. A student may be sexually harassed by a school employee, another student, or a non-employee. Both male and female students are protected. Moreover, Title IX prohibits sexual harassment regardless of the sex of the harasser, i.e., even if the harasser and the person being harassed are members of the same sex. As a condition of receiving funds from the department, a school is required to comply with Title IX prohibitions against sex discrimination. The law is clear that sexual harassment may constitute sex discrimination under Title IX. Sexual Harassment Guidance, January 2001, continued. Once a school has notice of possible sexual harassment of students, it should take immediate and appropriate steps to investigate or otherwise determine what occurred and take prompt and effective steps reasonably calculated to end any harassment and prevent harassment from occurring again. Sexual Harassment Guidance, January 2001, continued. School should initially discuss what actions the student or parent is seeking in response to the harassment, explain avenues for grievance, and an explanation of how it works. The specific steps will vary depending upon the nature of the allegations, etc., but must be prompt, thorough, and impartial. In some situations, a school may be required to provide other services to the student who was harassed, if necessary to address the effects of the harassment on that student. Sexual Harassment Guidance, January 2001, continued. During the investigation, it is a good practice for schools to inform students who have alleged harassment about the status of the investigation. A school must designate at least one employee to coordinate its efforts to comply with and carry out its Title IX responsibilities. The school must notify all of its students and employees of the name, office address, and telephone number of the employee or employees designated. We will now review Office of Civil Rights Guidance for Harassment and Bullying issued in October 2010 from the U.S. Department of Education. School districts may violate Title IX when peer harassment based on sex, sexual orientation, or gender identity is sufficiently serious that it creates a hostile environment and such harassment is encouraged, tolerated, not adequately addressed, or ignored by school employees. Harassment may be verbal, including name-calling, written, electronic, or physically threatening. School is responsible for addressing harassment incidents about which it knows or reasonably should have known. Harassment and Bullying Guidance, October 2010, continued. When the behavior implicates the civil rights laws, school administrators should look beyond simply disciplining the perpetrators. While disciplining the perpetrators is likely a necessary step, it often is insufficient. A school's responsibility is to eliminate the hostile environment created by the harassment, address its effects, and take steps to ensure that harassment does not recur. Put differently, the unique effects of discriminatory harassment may demand a different response than would other types of bullying. We will now review Office of Civil Rights Guidance issued in April 2011 regarding sexual violence. We will review the school's obligation to respond to sexual harassment. First, procedural requirements pertaining to sexual harassment and sexual violence. A school district must publish a notice of non-discrimination. Designate a Title IX coordinator. Establish grievance procedures that include notice of grievance procedures, impartial investigation of complaints, designated and prompt timeframes, and a notice of outcome. A school also has an obligation to correct discriminatory effects or remedies. There may be individual remedies, such as escorts in the school for those victims, separation from the perpetrator and the victim, counseling, medical remedies, and tutoring. School-wide remedies may include counseling, health, training, and publicity. We will now turn our attention to additional guidance issued from the Office of Civil Rights and the U.S. Department of Education regarding sexual violence in a question and answer document issued in April 2014. We have also provided a link to the PDF document, and we have included on this slide and the next slide questions that are included from the document and a corresponding page number for the answer. To prepare for the in-person training to be conducted on August 8, 2016, we request that you review the question and the corresponding answer as indicated in the PDF document. Again, on this slide there are additional questions and references in the PDF document regarding questions and answers regarding Title IX and sexual violence. We will now review Canyon School District Policy. Policy GBBA/JBA, Non-Discrimination. No district employee or student shall be subjected to discrimination in employment or any district program or activity on the basis of age, color, disability, gender, gender identity, national origin, pregnancy, race, religion, sexual orientation, or veteran status. Canyon School District is committed to providing equal access and equal opportunity in its programs, services, and employment, including its policies, complaint processes, program accessibility, district facility use, accommodations, and other equal employment opportunity matters. Canyon School District Policy continued. Policy GBBA/JBA, Non-Discrimination. This policy defines discrimination and harassment. Discrimination. Conduct, including words or gestures and other actions, which adversely affects an employee's or student's environment or results in disparate treatment or impact based upon age, color, disability, gender, national origin, pregnancy, race, religion, sexual orientation, or veteran status. Harassment. Conduct, including words or gestures and other actions, repeatedly communicated to another individual in an objectively demeaning or disparaging manner that contribute to a hostile, demeaning, or offensive work or school environment for the individual based upon age, color, disability, gender, national origin, pregnancy, race, religion, sexual orientation, or veteran status. Canyon School District Policy continued. Policy GBBA/JBA, non-discrimination. This policy also defines sexual harassment. Sexual harassment means unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when submission to such conduct is made either explicitly or implicitly a term or condition of an individual's employment, education, or participation in a school activity, or when submission to or rejection of such conduct by an individual is used as the basis for or a factor in decisions affecting that individual's employment, education, or participation in a school activity, or when such conduct has the purpose or effect of unreasonably interfering with an individual's employment or educational performance, or creating an intimidating, hostile, or offensive environment for that individual's employment, education, or participation in a school activity. Canyon School District Policy continued. Policy GBBA/JBA, non-discrimination. This policy also defines retaliation. Retaliation: any form or sanction or adverse treatment, including but not limited to intimidation, reprisal, or harassment of any individual because he or she has asserted or assisted another to assert a complaint in either a formal or informal manner with the school or the district or with any state or federal agency, or has testified, assisted, or participated in any manner in an investigation, proceeding, or hearing related to a complaint. Canyon School District Policy continued. Duty to report. It is the duty of every student and every employee to report discrimination, harassment, sexual harassment, and retaliation. Submission of a complaint. At the school level, the principal is responsible for receiving all complaints of discrimination, harassment, and retaliation. Canyon School District Policy continued. Policy GBBA/JBA, non-discrimination. Procedure. The principal or supervisor receiving a complaint will first document the complaint in writing. The principal or supervisor must forward a copy of the written complaint to the district's compliance officer, i.e., legal services. A principal or supervisor who does not follow the procedure as indicated may be subject to disciplinary action. Thank you for your attention regarding this presentation. If you have any questions, please contact the Department of Legal Services. Thank you.